2026 SCC Supreme Court of Canada 2026 SCC 12. The Treaty First Nations of British Columbia. On behalf of all signatory nations to the historic and modern treaties with the Crown in British Columbia. Appellants Plaintiffs v. Attorney General of Canada and Attorney General of British Columbia. Respondents Defendants Coram Wagner CJ. Inkarikatsanis Kate Rowe Martin Kasairer Obonsawin Jamal and Morau JJ. Reasons for judgment. Delivered by the court. I. Overview and disposition. This appeal concerns the constitutional obligation of the Crown to honor, in full, every treaty concluded with First Nations in British Columbia. The appellants represent all signatory First Nations to the historic Douglas Treaties, Treaty No. 8, and the modern treaties now in force. They seek declarations that 1. All such treaties remain binding nation-to-nation agreements protected by S. 35, 1 of the Constitution Act, 1982. 2. The Crown's honor requires strict adherence to the letter and spirit of each treaty, including full protection of the lands, waters, and resources expressly or implicitly reserved to the First Nations. 3. Neither the federal nor provincial government may unilaterally override treaty rights or permit development that causes cumulative harm to treaty territories. And 4. Any infringement must satisfy the strict justification test from R. v. Sparrow, 1991 SCR 1075, with meaningful consultation and accommodation as a minimum. The appeal is allowed. The judgments below are set aside. The court grants the declarations and remedial orders sought. All treaties listed below must be fully honored. The Crown is enjoined from authorizing any project or activity within treaty territories that would cause harm to the protected lands, waters, or resources without the free, prior, and informed consent of the affected First Nation, S, or, where consent is not obtained, without satisfying the Sparrow test in each case. First Nations ownership and stewardship rights under these treaties are affirmed and protected. 2. Facts. British Columbia is unique in Canada. Most of the province remains unceded, yet a series of solemn treaties were concluded with specific First Nations. These treaties are not historical curiosities, they are living constitutional instruments. The following treaties were placed before the court. Historic treaties. The Douglas Treaties, Vancouver Island Treaties, 1850 to 1854. 14 separate treaties negotiated by Governor James Douglas on behalf of the Crown with the following Indigenous groups on southern Vancouver Island: Tichimitsa, Kasampson, Wyamilth, Swengwang, Chilkowich, Chikeonin, Kakayakan, Chuhatsum, Tisukei, Saanish South, Saanish North, Salikwan, Quikar, and Kwakiol. These treaties cover approximately 930 square kilometers of land around present-day Victoria, Saanish, Sooke, Nanaimo, and Port Hardy. In exchange for blankets and other goods, the First Nations ceded limited surface rights for settlement, but expressly reserved their villages, cultivated fields, and the right to hunt, fish, and gather on the lands as formerly. Present-day successor nations include the Esquimalt, Songhees, Siinu Betcherbe, Tisukei, Tsawut, Sartlip, Pakwachin, Tsakum, Snunnamuxwa, Kwakiutl, Malahat, Nanowos, Namgis, Kayamox, and Gwesalanakwexdex W nations. Treaty No. 8, 1899, with adhesions, including McLeod Lake in 2000. Signed 21 June 1899, and subsequent adhesions, as part of the numbered treaties. In British Columbia, it encompasses the northeastern Peace River region, approximately 104,400 square miles within the province. The BC signatory nations are Blueberry River First Nations, Doig River First Nation, Fort Nelson First Nation, Halfway River First Nation, McLeod Lake Indian Band, Prophet River First Nation, Salto First Nations, and West Moberly First Nations. The treaty guarantees the right to hunt, trap, and fish throughout the tract for as long as the sun rises and the rivers flow, together with reserves and other benefits. B. Modern treaties, comprehensive final agreements. These are constitutionally protected modern treaties that confirm self-government, defined lands in fee simple, resource revenue sharing, and co-management rights while preserving core Aboriginal rights. Nisqually Final Agreement, effective 11 May 2000, Nisqually Nation, Nass Valley, Northwestern BC. Tsawwassen First Nation Final Agreement, effective 3 April 2009, Tsawwassen First Nation, Lower Mainland. Monolth First Nations Final Agreement, effective 1 April 2011, 5 independent nations on Western Vancouver Island. Huayot Ka, Ukate/Chi, Katiles 7 EtH, Takwat, Uchiklesat, and Yulu, Il Ath/Uklulit. TLA Ammon Final Agreement, effective 5 April 2016, TLA Ammon Nation, Sunshine Coast. Kayamox Treaty, a living agreement, ratified March 2025, Kayamox First Nation, Vancouver Island. Kitselas Treaty, ratified April 2025, Kitselas First Nation, Northwest BC. Kitsimkalam Treaty, ratified November 2025, Kitsimkalam First Nation, Northwest BC. These treaties collectively cover defined settlement lands, shared decision-making areas over resources, and explicit protections for water, fish, wildlife, and cultural sites. Territories belonging to First Nations through these treaties. The treaties affirm First Nations ownership, use, and stewardship over all lands, waters, and resources within the Douglas Treaty areas, southern Vancouver Island parcels. The entire Treaty 8 area in northeastern British Columbia, Peace River, Fort St. John, Fort Nelson, and surrounding watersheds. The Nisqually Nass Valley lands and associated resource areas. Tsawwassen lands in the Fraser Delta and adjacent marine waters. Monolth coastal and foreshore territories on western Vancouver Island. TLA Ammon, Kayamox, Kitselas, and Kitsimkalam defined treaty settlement lands, including forests, rivers, and marine resources. All such territories, waters, and resources remain under the ownership and control of the respective First Nations, pursuant to the treaties. The Crown holds only the limited rights explicitly granted. For visual context of the geographic scope, see the maps below illustrating historic and modern treaty areas in British Columbia and Canada. 3. Constitutional Framework. Section 35, 1 of the Constitution Act, 1982 recognizes and affirms the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada. Treaties are not mere contracts. They are sacred covenants embodying the honor of the Crown, Hayden Nation v. British Columbia, Minister of Forests, 2004, SCC 73, para. 20, Mikisew Cree First Nation v. Canada, 2018, SCC 40, para. 21. The Crown must interpret treaties generously and in accordance with the intentions of both parties at the time of signing R. V. Marshall, 1999, 3 SCR 456. The Sparrow Test governs any infringement. The Crown must demonstrate a compelling and substantial objective, that the measure is consistent with the honor of the Crown, and that it has minimally impaired the right. Consultation and accommodation are mandatory. Cumulative impacts of multiple projects must be considered. Tsilhqot'in Nation v. British Columbia, 2014, SCC 44. 4. Analysis. The evidence before this court demonstrates systemic and ongoing breaches. Resource extraction, pipelines, forestry, and water allocations in treaty territories have caused cumulative harm to fish stocks, wildlife corridors, traditional hunting grounds, and sacred sites. These actions were authorized without adequate consent or justification. The Crown cannot override treaties by legislation or executive action. Treaties bind both levels of government. Delgamuukw v. British Columbia, 1997, 3 SCR 1010. Modern treaties explicitly preserve Aboriginal rights and add self-government and co-management mechanisms. These two are constitutionally protected. First Nation citizens are entitled to live free from harm on their treaty lands. The treaties guarantee not only physical territory, but cultural, spiritual, and economic continuity. Any government action that threatens these rights violates the honor of the Crown. V. Remedies and orders. This court declares that all listed treaties are valid, binding, and must be honored in their entirety. The Crown is under a constitutional duty to protect all lands, waters, and resources identified in each treaty as belonging to the respective First Nations. No government may authorize development within treaty territories that infringes treaty rights without the affected nation's consent or full Sparrow justification. Immediate injunctive relief is granted restraining further harmful activities pending proper consultation and accommodation. The Crown shall negotiate implementation plans with each nation within 12 months to restore and protect treaty rights. Costs are awarded to the appellants on a full indemnity basis. The Crown's honor demands nothing less. Reconciliation is not a slogan. It is the constitutional imperative that treaties be kept. Judgment accordingly. This judgment is binding on all governments and affirms the sovereignty and rights of the First Nations of British Columbia under their treaties. All treaty lands, waters, and resources remain under First Nations ownership and protection as originally agreed. #Pierre Poilievre, #Mark Carney, #Conservative, #Liberal, #Royal Family, #First Nations, #British Columbia, #Alberta, #Ontario, #Canada.